Yes, Mr. Richardson.
My Lords, I appear with my learned friend Mr. Copeland and my learned friends Mr. Cuddigan and Gamser here for Neo. Your Lordships are aware that this hearing can be divided up into three parts. There's my appeal, my learned friend's respondent's notice, and then my learned friend's application to run new points, rely on new evidence, and for disclosure, and my cross-application seeking to strike out aspects of his respondent's notice which amount to new points not run below. Subject to your Lordships, my learned friend and I have spoken, and we're agreed that my appeal should go first, and that we anticipate will be complete before the end of today, which should leave plenty of time for the other aspects on Wednesday and Thursday.
Yes, well, you have the time available to. We'll see whether we need it all. There are a number of points that need to be got through, but we'll take it as we go.
Oh, I'm grateful. So, my Lords, on my appeal, I was proposing to do this. I was proposing to have a brief introduction and provide some background to the case. Then I was going to look at the case law in a little bit of detail. Then I was going to turn to the judgment to show where we say the judge fell into error. There are 4 grounds of appeal that permission has been granted on for us, but our focus will be very much on grounds 1 and 2, and I will deal with them in that order. So, my Lords, first of all, introduction. I think my Lord Justice Jackson and Lord Justice Arnold may recognise the party names in this case. My Lord Justice Arnold first heard the applications in this case way back in 2016, over a limitation period ago, where amongst other things you made orders requiring Neo to produce samples to be tested for infringement. And my Lord Justice Jackson heard Neo's unsuccessful appeal against the findings of liability in this court. As a number of the judges have noted during the course of this litigation, it has been long and hard fought, and at the same time as these UK proceedings, Rhodia has successfully brought infringement proceedings under the same patent in Germany, where an inquiry as to damages is also on foot. And although the patent has now expired, the long lifetimes of the platforms for which the patented cerium oxide is qualified means that damages are potentially still accruing. So I'm going to turn to the background now, and if I may, perhaps unconventionally, show you the patent very briefly. That is in the supplementary bundle at tab 1. And if I could just draw your attention to a few of the paragraphs in the introduction. First, if I could ask your Lordships to read paragraph 1 of the patent, page 2. So the patent is all about the preparation of ceric oxide, expressly useful for catalysts. And then there's some introductory explanation about the catalysts for which the cerium oxide is appropriate. And perhaps your Lordships would also read paragraphs 2 to 4.
I can't imagine what I'm going to gain from doing so. Would you like to tell me?
It may be relevant. There's a question about scope of duty and what the parties would anticipate infringement.
All right, well, stripping out all the technical stuff, what is the point out of paragraphs 2 to 4?
The point is that the purpose of the cerium oxide is to absorb and then release oxygen during the catalytic process, and that's an essential part of the catalysts which are made. And in particular, it's important, as explained in paragraph 5, that the ceric oxide has high surface area, even under high heat conditions. And the invention in this patent, as summarised in paragraph 12, is providing this high surface area even after high temperature treatment. As paragraphs 14 and 16 explain, the key is providing a surface area of not smaller than 30 metres squared per gram after treatment at 900 degrees for 5 hours. And as 16 explains, and as claim 9, it wasn't asserted in this case because Neo do not themselves make catalysts, but there is a claim not only for cerium oxide in this patent, but also for the catalysts made with that cerium oxide. So, my lords, that's all I wanted to show you in the patent. And then, if I could ask you to look very briefly at the judgment of Rhodia and QC on liability, and there's just one passage in that judgment that I'd like to show you. That's tab 3. And on page 29 of the bundle, there's paragraph 32, where the judge made findings based on the evidence of Dr. Brophy, who was Neo's expert. If you could just read paragraph 32, I'd be very grateful.
Yes, so that's in your skeleton argument.
Yes, of course. And then next on the background, could I take you to tab 8? And this is an extract from the witness statement. Sorry, tab 2 first of all, which is an extract from an affidavit of Karen Brown, and this was part of the Civil Evidence Act notice material we relied on before the judge. And the reason I'm taking you to this is it provides some of the background to the judge, which the judge wasn't perhaps able to, for reasons of brevity, to put into the judgment, and I don't think any of it's in dispute. If I could...
When you say the judge, you mean Mr. Wyand?
No, I'm now on to the damages inquiry.
So right, so this is so this was Civil Evidence Act material before the judge.
Yes, my lord. And this was an affidavit submitted by Karen Brown, who was the managing director of Neo. It was an affidavit submitted in the Dutch proceedings, which is why it only appeared as a CEA notice here. And I just want to show you some of the commercial background, which I don't think is in dispute, but which is actually set out by her. And so if I could take you, please, to page 19. And could I just ask you to read paragraphs 20 to 22?
Yes.
So the point there is she's accepting that there are only two players really in this market, Rhodia and Neo. And then if you turn the page, and if I could ask you to read paragraphs 25 to 27. And really, so the point I've emphasised there is she explains that there are 3 washcoaters in Europe: BASF, Umicore, and Johnson Matthey. And of course, this case is focused on dealings with one of them, Johnson Matthey. And then at the end of 27, she explains that years of testing are required before a new catalyst product may be brought onto the market. And then, if I could finally ask you just to read paragraph 30, where she explains the development process.
Yes.
And the point there to make is that, as she explains, even if there's only a single customer on a platform, the customer is selected based on a combination of test results, price and service. That would include capacity, and we'll come back to that in relation to the judge's findings on that a little later. Finally, by way of background, could I just show you a few paragraphs in tab 8. Starting on page 73 of the bundle. And this is an extract from a witness statement at the inquiry from Richard O'Sullivan, who is an ex-employee of Johnson Matthey, and the judge described him in her judgment at paragraph 23 as a reliable and knowledgeable witness whose evidence was not strictly challenged. And so, again, it's just by way of background, I can show you a few of the paragraphs of his statement. Firstly, if we go to page 74, there's a heading before paragraph 17, how JM1 emission control catalyst business with its automotive customers, and he goes through various stages in that process. And perhaps if I could ask you to read paragraphs 25 to 27, please.
Yes.
So the points to be taken from here that Royston was the key technology centre for Johnson Matthey worldwide. At the beginning of paragraph 26, he explains that a key measure of whether a catalyst works well or not is what it does after it's aged, i.e. seen some engine time, and your lordships will see the connection with the invention in the patent and the ability to retain high surface area after high temperatures. And then he explains how these tests are carried out, and the aging is mimicked by raising the temperature. And then he explains how they have all these test cells, different engines in Johnson Matthey in order to carry out the tests, and that's obviously why they require sufficient amounts of material to test the catalysts. Then if I could ask you to look through paragraphs 30 to 33, which is where he explains the offer of the catalyst to car manufacturers and the shootout process. And so he there explains in 31 that you require many examples of the catalysts on the different prototype vehicles. And then in 33 he refers to the emissions regulations, and it's essential that having got a catalyst approved, the same material is used going forward to maintain compliance with the regulations. Two further short passages, please. Just first of all, 39 and 40, if I may. emphasising there the requirement by JM for hundreds of copies of the catalyst to be tested following the shootout or technical assessment as part of the prototype process. And then finally, in paragraph 51, where he explains about the fingerprint of the catalysts, I just ask you to read that.
Yes.
So in summary, there was a very considerable testing and approval process to go through to get a raw material such as cerium oxide selected, first of all by the catalyst manufacturer, such as Johnson Matthey, and then chosen by the car manufacturer to be used in a particular platform following the shootout and lengthy prototype testing. One of the reasons for this very lengthy and thorough procedure was the emissions legislation, and once selected, neither Johnson Matthey nor the car manufacturer would want to vary the specification or the characteristics of the catalyst, and there was an expectation that supply of that material would continue for many years. And much of this is reflected in the judgment of the judge, but in our submissions, as we'll say later, it wasn't properly reflected in the final analysis she carried out on causation. So with that background, I was going to turn to the law. And there were 8 authorities which I think I ought to go to. I know we've covered a lot of them in the skeletons, but there are some that just need look at in a bit more detail, if I may. So if we could start off in Joint Authorities Bundle 1 at tab 4 with the first instance decision in Gerber. So this is Mr. Justice Jacob, as he then was, in the Patents Court.
Mr. Richardson, I don't want to take you out of your course, but when looking at authorities, it's always helpful to the court if the court knows in advance what proposition of law counsel contends that the authorities support. Now, it may be that the nature of your argument doesn't admit of a short summary, but if you could give us a short summary of the legal proposition which you're seeking to establish before going to the authorities, I, for one, would find that helpful.
Of course, my lord. What I was proposing to go to Gerber for were for 2 reasons. Firstly, just to make the facts clear, to show how the convoyed goods in Gerber was said to be sold, and the reasons that Mr. Justice Jacob gave for finding that they were recoverable. Also, for his observations, and which were then reflected by Lord Justice Staunton in the Court of Appeal on the duty and the scope of recovery under the Patents Act. And that was interspersed with Samco in the House of Lords, which I was going to go to as well, and then reflected by Lord Justice Staunton in the Court of Appeal. Now, it may be that you feel all of those aspects are familiar.
Well, not at all. I'm not trying to dissuade you from going to authorities. On the contrary, we are plainly going to need to look at a number of them. What I'm trying to ascertain is the direction of travel. So, let me be clear. It might be helpful just to be clear as to where I think we're going. Because what we see on the face of the skeleton arguments is that the parties seem to be like ships passing in the night. This is why I'm asking the question. In particular, you have relied in your skeleton argument upon the Bonington case and the Williams case, which are cases, as I see it at the moment, about factual causation. They are cases about an exception to the normal rule that you have to show but-for causation. And if we're going to look at those, we would also have to look at other cases which have not yet been cited, such as AB and Ministry of Defence, Hennigan and Manchester Dry Docks, FCA and Arch. And we have to get into questions like, is this a single cause of harm or is it a multiple cause? Is the injury divisible or indivisible? And so on and so forth. But at the moment, I don't understand why we would need to go into all of that, because you have a finding in your favour of but for factual causation. Therefore, the debate, as it seems to me at the moment, is one about legal causation. And therefore, it's the authorities on legal causation that we need to be looking at. And I can quite understand that in that context, you will certainly be wishing to be relying upon Gerber. But it would nevertheless be helpful, as I say, if you could give us some steer as to the direction we're heading in.
Yes, and I quite take your Lordship's point on the but-for causation. We accept that that is not a relevant part of the appeal because it's been found in our favour and it's not challenged. So I'm trying to direct my submissions towards the legal causation aspect. And there may be something between my own friend and I as to whether or not necessarily Bonington castings, but maybe Williams helps on legal causation. But I perfectly accept that that's what I need to direct my submissions to, and the but-for is found in my favour, and we're looking at a narrower question than that. So I certainly don't wish to waste time on that aspect.
Well, having now discovered what field you're grazing in, could you then help us further as to, in a sense, what's the global proposition that we're going to be the better for, having looked at the 8 cases?
The global proposition is firstly working out whether there is a scope of duty question that arises in this case, and secondly, where if we're going to the Manchester 6 points in Manchester that you're meant to apply, certainly in negligence cases, where we say the judge fell into error in this case, and our submission is that she fell into error under question 6, and she has found some sort of either an intervening cause or an aspect of remoteness, which she concluded was not prevented recovery in this case. Now, my learned friends, I think, seek to characterise it under, her finding was under question 5 in Manchester, some sort of proximate cause aspect, which may not be remoteness. And that's what I was going to go to some of the later cases to look at. The other aspect I want to touch on is the counterfactual, because we say we accept the observations of the majority in Manchester Building Society that the counterfactual is perhaps only a cross-check. But we say, had the judge used the counterfactual here, she would have realised that everything pointed towards the damage being not remote and there have been no intervening acts, and that should have directed her towards a finding that there was a legal cause by the infringements of the damage that occurred.
A legal
legal cause.
Cause.
Yes. Not she. Well, I'll come on to the point about the and a little bit later, but we say that she didn't ask herself the right question, and if she had done, she'd have come up with a different answer.
All right.
So, well, maybe I can be more brief on the authorities, and that's
No. Only wanting to keep abreast. Could you just tell us what the 8 cases are before you start on this?
So I was going to go to Gerber first instance and on appeal with Samco in between, because Lord Justice Staunton refers to it. Then I was going to look at Kuwait Airways. Then I was going to look at Xena, which is His Honour Judge Burse's inquiry case, which the judge, we say, wrongly tried to draw too many parallels with in her assessment. Then I was going to look at Williams and Bermuda, and then finally Manchester Building Society and Meadows. So I hope I'm.
I make that 6.
There were
If
two
you're counting
Gerber and
Gerber
Samco.
okay, you're counting Gerber
Gerber
twice.
twice,
I'll give you
I
that. Then I get up to 7. Unless I'm missing one.
Samco, Kuwait,
Yeah,
Xena, Williams,
6.
Manchester Building Society, Meadows.
Meadows. Thank you.
Thank you. Right, we're with Gerber, are we?
We are, and I will, with your lordship's encouragement, take it as fast as I can. So the pointing.
No, I'm sorry. I don't want to be misunderstood. I wasn't in any sense suggesting this because it's of course the case that my lord and my lords may be quite familiar with a lot of this. Certainly more familiar than I will be. So don't feel that you have to rush through it. This is important.
I'm grateful. So if we can pick it up in Gerber, tab 4, page 69, and at line 9 on page 69, the judge, Mr. Justice Jacobs, explains what the patent was about in that case. The patent was about CAM machines, that's computer-assisted manufacturing machines. But he goes on to explain at line 29 that another important development which occurred approximately in parallel with the introduction of the Gerber inventions lay in the field of computer-aided design, CAD. So there were the two types of machine in that case, CAM machines, which were the patented machines, and then CAD machines, which were related. And he goes on to explain on page 70, at line 43, he explains that CAM machines are large and expensive, but they are sold with warranties, initial servicing, sometimes 3 months, sometimes more, and some spares. Invariably, each machine will have further servicing and spare part needs, as will its associated CAD. And then if we turn on to page 72, we'll see what the factual scenario which the judge was presented with down at line 49. And he explains, overall in the pre-expiry period, Lectra sold 25 patented machines. In addition, 2 sales were made to Irish customers of machines shipped to Ireland via the United Kingdom. And there's also a post-expiry sale which should be treated as a direct infringement. And so the question arose whether the pre-expiry activity amounts to an infringement. And he goes on to explain the top of 73.
Just before you go on, you've placed some emphasis in your skeleton argument on the Irish sales.
Yes.
But as we can see there, they were shipped via the United Kingdom. So that would have been an infringing act in the UK.
That seems to be the case, my lord. It's not easy to get the detail, but that does appear to be the case. Like I said.
Yeah.
And then so we see the top of 73, the judge explains that there were 25 patented machines were sold for a total of 3.6 million US dollars, but the claim was for 3 times that, 9.75 million dollars, because of the convoyed goods. And you can see in the little table at line 20 where those extra damages were said to come from. Some were from the CAD machines, that's point 2, some were from the spare parts, some was from servicing, and then post-expiry and the Irish sales, and that's how it all totted up. And if we go on to page 77, the judge there deals with a disputed principle as to whether or not the convoyed goods, which are not patented, could be claimed for by way of damages. And he summarises at line 30 the defendant's argument that where they said, Lectra said that Gerber cannot complain about lost sales of any of these unpatented things. And he goes on to deal with this point of principle, and he starts at line 46. He says, line 47, Lectra's argument about spares and so on depends upon a distinction between that which is within the monopoly, i.e. a subsisting valid claim, and that which is not. And if perhaps your lordships would just read on to line 30 of the following page, where he deals with the question of what's technically in the claim or not.
Yes.
So he summarises at line 30, the damages did not turn on legal niceties, they turned on commercial considerations. And we say that's the overriding factor that should be in mind in a damages inquiry in a patent case. We say in this case, the judge did not pay sufficient attention to the commercial considerations. On page 80, so he goes on to look at two of the cases which were relied on to suggest that it was not permissible to recover for unpatented goods, and he rejected that and summarised the position on page 80 at line 29. And the three factors he summarised it as, he says, first of all, one must distinguish between the wrong and the damage flowing from the wrong. He said any damage which foreseeably flows from the wrong is recoverable, but in some cases there may be policy reasons for restricting damages even where the damage foreseeably flows from the wrong. And then he goes on to analyse the difference between the wrong and the damage at line 41 onwards. And if I could ask your lordships to read that passage over to line 20, sorry, line 45 on the next page.
Yes.
And so we say there are significant parallels with this case. The question should have been for the judge, were the wrongful acts of infringement the source and origin of the losses? We say they were. And we say where not only were the losses foreseeable, but were also intended by a defendant, then there is an important policy point that you need to deter defendants from carrying out the sorts of actions, as in Gerber, also in this case. And if you don't deter them, then they are likely to go ahead and commit the wrong, knowing full well that the benefits they accrue are going to be significant, and that is not good policy for the reasons Mr. Justice Jacobs set out. And again, line 36, that paragraph there, we say there is a distinction in law.
Sorry, before you go on,
yes.
You seem to be saying there that intention adds something to foreseeability.
Well,
but
yes.
why?
Well,
If it's foreseeable, why is that not enough for your purpose? What does intention add?
Because as some of the articles and cases recognise, if the defendant has actively foreseen or intended the damage to take place, then it is only those defendants who can be deterred. Because if you're attempting to deter someone who hasn't thought about something, then the deterrent won't have any effect. And so there are policy reasons why a defendant who's intended something should be prevented from gaining the benefit of that intended outcome, because otherwise they'll just go ahead and do it next time and carry out the infringement.
Well, in some areas of law, intention or a requirement for intention is a way of limiting the scope of liability.
Yes.
But that's not what you're talking about here. You're not talking about any limits on scope of liability, because we're talking here about a tort of strict liability.
Yes.
So you don't need intention, but equally, intention doesn't make it any more of a tort than it was.
No, but I suppose there are two levels we rely on. Firstly, there's the fact that it was intended means that we submit the judge should not have found the outcome too remote, because it was absolutely, in the eyes of the defendants, what they wanted to do. They wanted to sell these goods abroad by virtue of the infringements. And so we say that intention is an antidote to remoteness. And we say the policy reasons for that are, as Mr. Justice Jacob has outlined here, that where someone is intending to make a benefit by a wrong, then the deterrent effect of making them pay for that wrong might prevent them doing it in the future, and that's an important policy reason.
But you're not arguing in favour of aggravated damages or punitive damages.
I'm not. I accept that.
And I come back to the question, I understand the point of foreseeability, but if we assume in your favour that it's entirely foreseeable, the damage that is sustained, what does intention add?
As I say, it's an antidote to an argument on remoteness.
But why does remoteness not fail on foreseeability?
Well, we say it should do. So in that case, it's not necessary,
right,
for me to rely on this, because we say.
So that submission is predicated on the assumption, as it were, that the judge has found that this is not recoverable because it's too remote.
Yes, my lord. And we'll come on to her judgment later.
Yes, because that it's not. You'll get to it. It's not entirely clear to me that that's what she found.
No, I accept it's not easy to discern precisely why she found we lost. But,
just so.
But the references to proximate cause seem to carry with it a reliance on some sort of remoteness aspect. So yes, the other point, my lords, just on paragraph, the paragraph at line 40, where Mr. Justice Jacob distinguishes between the Catnick case, where the unpatented lintels had nothing to do with the infringing article, whereas in this case, the CAD and service and sales were closely connected to the infringing article because they were for the infringing machines. And of course, in the case before your lordships today, we say there is a very close link between the foreign sales and the materials being dispensed in the foreign sales and the infringing material that was used in the UK. In fact, it is technically the same material, albeit that that it can be said that the foreign material is not infringing because it's not infringing a UK patent. So we say there is a very close connection which the judge failed to place sufficient weight on. Well, then Mr. Justice Jacob goes on to discuss patterns of conus. We may have to come back to that on my learned friend's respondent's notice. Then he goes on to discuss the US position, and he satisfies himself, or he comforts himself, that where there is anticipated sales of non-infringing or unpatented items in the US, they are also still recoverable, and we may have to come back to that too on my learned friend's respondent's notice.
What do you say about what he says at page 402 of the report at line 17, this head of damage is regularly allowed provided the plaintiff can establish a sufficient nexus between the infringement and the damage.
Yes, well, I think he's just talking about as a causation point there. Or are the infringing acts and the acts complained about, or the for which damages are sought, sufficiently connected? And that really is the same as the point he made about Catnick, where the lintels had nothing to do with the infringing article, but in Gerber, the convoy goods were sufficiently connected. So I think he's, in my submission, he's saying that it's the same considerations are appropriate in the US as in the UK. Finally, on this judgment, there's the passage at line 14 on page 84, where he deals with the but-for question and his Adam and Eve analogy. And although I agree that it's not relevant to my appeal, the but-for aspect, it's helpful to have in mind what the but-for test is trying to do and where it falls down. And this is a helpful analogy in our submission.
But would you accept the statement he makes at lines 22 and 23? The general policy of the law of the tort in modern times is to provide compensation for damages foreseeably caused by the wrong. We could now see is unequivocally wrong.
There are additional factors, yes, my Lord.
Well, it just seemed plain wrong. I mean, all the House of Lords Supreme Court authority from Samco onwards tells us that that's wrong.
Yes, in the cases where you are required to also think about the scope of duty, then of course it's wrong and you've got to apply the other factors. But in some senses, Mr. Justice Jacob here is saying no more than Lord Hoffman in Samco and the question of the mountaineer. He's just the mountaineer's
he completely fails to consider that aspect of it, doesn't he?
Well, that wasn't a relevant consideration in the case before him. I accept that. But in terms of how are damages to be calculated for patent infringement, we say that Mr. Justice Jacob was right to say it's a question of foreseeability, it's a question of remoteness, and it's the conventional approach. And in our submission, Manchester Building Society and Meadows and Carn don't really change that.
Right, so to be clear, your proposition of law is that Mr. Justice Jacob was right so far as we are concerned. Never mind about other torts. You are saying that so far as the tort of patent infringement is concerned, it is sufficient for there to be one, factual causation, and two, foreseeability.
There also needs to be remoteness and no intervening.
Well, you say foreseeability is the answer to remoteness.
Yes, they can be treated together.
So it is your case that all you need is factual causation and foreseeability.
And remoteness deals with that is a question of legal causation as well.
You say foreseeability is the antidote to remoteness. So I reiterate, and tell me if I'm going wrong somewhere. This is your case.
Yes.
That all you need is one, factual causation,
yes,
and two, foreseeability.
Yes, and the damage is not too remote. And there are debates about whether foreseeability and
you
remoteness
keep on
are the
saying
same thing.
and not too remote, but I'm failing to understand what your distinction is between the damages being foreseeable and the damages not being too remote. Because I thought on your case those were two sides of the same coin.
My lord, they may well be. There is the reason I'm hesitating is some of the cases seem to suggest that foreseeability and remoteness are different things, and to the extent they are different, then we would accept you need to satisfy both aspects, and there has to be, if there was an intervening act by an independent third party, that might also be a reason not to award damages, but those don't apply in this case.
So your second proposition is that there are a range of possible policy considerations which limit recovery.
Yes.
Foreseeability, remoteness, novus actus being examples.
My lord, yes.
Thank you.
So then we have in the next tab is the Samco decision, which will be well known to your lordships, no doubt, and just a few passages from here, if I may. Firstly, so the judgment of Lord Hoffman starts on page 122 of the bundle. And then this, of course, was a valuation case. This was the case where the mortgages were valued and then the market dropped, and the question of whether there was liability for the drop in the market as well as the misvaluations. And on page 124, Lord Hoffman first of all cites from Caparo and Dickey, Lord Bridge at B. And he says, it's never sufficient to ask simply whether A owes B a duty of care. It's always necessary to determine the scope of the duty by reference to the kind of damage from which A must take care to say be harmless. And he says, in the present case, there's no dispute that the duty was owed to the lenders. The real question in this case is the kind of loss in respect of which the duty was owed. How is the scope of the duty determined? In the case of a statutory duty, the question is answered by deducing the purpose of the duty from the language and context of the statute. And this is the quote that Lord Justice Staunton comes back to in the Court of Appeal in Gerber. And we say that is the appropriate test for a tort such as patent infringement. And then he goes on to give the Mountaineer example on page 125. So if your lordships would just remind yourselves of the paragraph just below C to E, please. And then on page 126, if I could just ask you to read the first two full paragraphs on the page where he introduces the aspect of common sense, which we'll have to come back to. And so we accept that there does have to be a sufficient causal connection between the infringement and the damage. That's the same as the point Mr. Justice Jacob was making about the lintels and whether there was any connection with the patented goods. And one way of testing whether there is the causal connection is to apply the counterfactual and to ask, would the damage have occurred even if the information which he gave had been correct? So even if there hadn't been a tort, would the damage have occurred? And that is an appropriate cross-check to test whether there is sufficient causal connection. And in the present case, we say it points very strongly towards a finding that damages should be awarded for the foreign sales. I'll come back to the counterfactual aspect when we get to the judgment. So that was Samco, and then in the Court of Appeal on Gerber, which came, Samco is in between, we have Lord Justice Staunton, if we can pick it up on page 145, and this is 145 is where he asks the question, what is the scope of recovery for infringement of a patent? He sets out the arguments and the argument that non-patented goods couldn't be recovered, damage couldn't be recovered for those. And he goes on to explain on 146, lines 24 onwards, and this is the passage referred to by the judge. And we say this is still good law in respect of patent infringement. The overriding aspects are, the overriding principle is the victim should be restored to the position he would have been if no wrong had been done, that the victim can recover the loss that was foreseeable, caused by the wrong, not excluded from recovery by public or social policy.
So could I just ask you this? He says at line 24, in the ordinary way one would expect the damages recovered would be governed by the same rules as with many or most other torts. And then the propositions that he's quoting from the Halsbury's are from tort, not patent law specifically.
Yes.
So to what extent would you accept that we are here applying general tort rules, and to what extent do you say that patent law is either different in general or different from other specific torts?
I would accept that general tortious principles should apply to recovery of damages under patent law. The difference with patent law is that as it is a statutory tort and a tort of strict liability, that the court does not need to spend much time asking questions about duty, because the points about the duty question is to try and unravel whether or not advice has been given, the difference between the information cases and the advice cases. If information has been given, then it's envisaged that the information will only have been given for a particular purpose, and therefore the damage may be limited to that purpose. That doesn't apply in patent law because it's a strict liability tort where all, in our submission, all economic consequences of the infringement, which are foreseeable and not too remote and not excluded from recovery by public or social policy, should follow. So it really is a much simpler test, but we do accept that ordinary tortious principles in relation to foreseeability and remoteness, etc., do still apply.
Thank you.
And the point he makes at line 43, this is where the narrowing comes between the but-for question and the ultimate recoverability question. It's not enough that the loss would not have occurred but for the tort. The tort must, for present purposes at any rate, be, as a matter of common sense, a cause of the loss. And we accept that. And that's why I'm trying to direct my submissions towards the cause of the loss, or a cause of the loss, to be more correct, and that is reflected in his wording at line 44 and also in the summary from Halsbury just above.
So, as I understand it, therefore, you accept that factual causation is not enough.
Yes.
So therefore, in answer to the question I was putting to you earlier, it's not your case that you merely have to establish factual causation and foreseeability and non-remoteness if that's different. You accept that you also have to establish legal causation.
My Lord, yes, to the extent that is different from the questions of foreseeability and remoteness. We say that there's a further filtering step after the factual but-for question, which is there a further reason to restrict losses? And one of the ways you do that is through foreseeability and remoteness. And that is effectively the same as asking the counterfactual question that Lord Hoffman sets out. And is it really the cause? Was the doctor's negligent advice really the cause of the mountaineer's accident? Or was it nothing to do with it, because in fact the accident occurred for reasons nothing to do with his knee? And that's why, in that case, Lord Hoffman suggested that there wouldn't be damages recoverable for the accident up the mountain. And that is because there wasn't sufficient cause between the negligence and the injury. And in contrast, we say in this case, there is clearly sufficient cause between the infringements and the sales which we're seeking recovery for, because in the counterfactual, they just would not have occurred. So we contrast this case with the Mountaineer, where the damage would have occurred in any event. In our case, there would have been no foreign sales had the infringements not taken place. And I can go on.
But that seems to involve an acceptance that it is at any rate legitimate to ask whether there is a sufficient cause.
My lord, that's right, and that's what Mr. Justice Jacob accepted in Gerber. That's why the difference between Adam and Eve and the cause that the infringements in Gerber had also given rise to the servicing contracts or the other goods. There has to be a sufficient nexus. I do accept that. But that is can be dealt with as much as a question of forcibility and remoteness as by giving it some other label, such as proximate cause or nexus or duty, and we say there isn't really a difference. In the Gerber case, sorry, we'll come to the Xena case. In the Xena case, the sales of non-patented fixed platforms were not sufficiently linked to the sales of the infringing goods for recovery to be allowed. And that's why His Honour Judge Burr said it wouldn't be possible to recover.
Would you accept whether there's something is a sufficient cause or proximate, if one prefers that label, is a value judgment?
Well, there are two levels at which we put it. Firstly, the judge asked herself the wrong question because she was trying to find the cause, and she should have been asking whether it was a cause. So that's one area.
That seems to be an answer to a different question to the one I asked.
Well,
my question was,
yes.
do you accept it's a value judgment?
I accept that there are multiple factors which a first instance tribunal has to look at to evaluate whether or not that level, that threshold has been reached. But in this case, we say the judge didn't take into account all the factors she should have done and perhaps placed too much weight on factors which she shouldn't have done, and that's why we say she fell into error. So of course, it's a question which involves a number of different aspects. Whether it engages the Aldi principle, we may have to come on to.
All right.
But in this case, we say the judge plainly fell into error. Back into Gerber in the Court of Appeal, and 147 is where, line 35, is where Lord Justice Dalton summarised his views on recovery under the Patents Act. So line 35 to 40, we say that still applies today, still good law. The Patents Act is all about protecting a monopoly, and the purpose of the monopoly is to give the patentee a commercial advantage, and therefore where there has been commercial losses suffered as a result of infringements of the monopoly, we say damages should flow. And he then goes on and reviews the same cases, or some of the same cases that Mr. Justice Jacob reviewed, and he concludes on 149, having reviewed them at line 45. Viewing the case as a whole, I cannot find any rule of law which limits damages for infringement in a patent case in such a way as to exclude the loss claimed by patentees in the present case. And we say again that there is no rule of law applying it in that way. So that's Gerber in the Court of Appeal. Then
Should we just pick up what he says at 456?
of course,
At line 6 to
the
14.
supermarket example.
Yeah, the
Yes.
supermarket example.
Yes, and that again is consistent with our submissions, we would say that under general tortious principles, there would be a problem on causation or remoteness with the example he gives. But that's not something that applied to the Gerber case, and we say it doesn't apply to the present case either.
Yeah.
Next, my lords, is Kuwait Airways at tab 8. And the passages I wanted to draw your attention to here begin on page 237 of the bundle. And this is really a forerunner to the steps identified in Manchester Building Society and Meadows. So this is Lord Nichols at paragraph 69. How then does one identify a plaintiff's true loss in cases of tort? And he identifies, right at the bottom of the page, the first of these inquiries, widely undertaken as a simple but-for test, is predominantly a factual inquiry. And we accept that. Then he goes on, paragraph 70, second inquiry, although this is not always openly acknowledged by the courts, involves a value judgment, ought to be held liable. And he explains just below B, the law has to set a limit to the causally connected losses for which a defendant is to be held responsible. In the ordinary language of lawyers, losses outside the limit may bear one of several labels. They may be described as too remote, because the wrongful conduct was not a substantial or proximate cause, or because the loss was the product of an intervening cause. And he goes on to talk about mitigation. And so we rely on this passage to bolster our submission that this narrowing or the value judgment can be encompassed by questions of remoteness. And in this passage, Lord Nichols seems to correlate the question of remoteness with the question of whether something is a substantial or proximate cause. And one can see why you might use the word proximate to describe a test involving remoteness. And this is a legal test, not the factual test he's talking about. So we say this passage clearly supports our submission that to the extent that the judge was asking the question, is it the substantial or proximate cause, she was asking herself the wrong question. It only needs to be necessarily a substantial or proximal cause. And this is what Lord Nichols reflects here. And then he goes on to introduce common sense in 71. In most cases, how far the responsibility of the defendant ought fairly to extend evokes an immediate intuitive response. This is informed common sense by another name. Usually there's no difficulty in selecting from the sequence of events leading to the plaintiff's loss the happening which should be regarded as the cause of the loss for which the purpose, for the purpose of allocating responsibility. In other cases, it may be more difficult, and you may need to ask what is the scope of the defendant's duty. And then in 72, he says, the purpose of the relevant cause of action is not confined to the second evaluative stage of the twofold inquiry, that's the legal question. It may also rise at the earlier stage of the but-for test, to which he now returns. So then he goes back to look at but-for. And then he returns on page 239 to the difficulties that sometimes arise in tortious cases just above C. He says, torts cover a wide field and may be committed in an infinite variety of situations. Even the sophisticated variants of the but-for test cannot be expected to set out a formula whose mechanical application will provide infallible threshold guidance on causal connection for every tort in every circumstance. He says, in particular, the but-for test can be over-exclusionary.
Do we need to worry about this because we're not concerned with exceptions to but-for here?
Indeed. And then if we could go on to page, paragraph 99 on page 244. And there's a passage here which may be relevant to your Lordship, my Lord, Lord Justice Arnold's question about intention. And Lord Nichols tries to deal with the difference between reasonable foreseeability and whether the loss arises naturally and directly from the wrong. And he notes in paragraph 100 the foreseeability test is likely to be more restrictive. And he goes on to say in 101, in contrast, the less restrictive test is applicable in deceit. The more culpable the defendant, the wider the area of loss for which he can fairly be held responsible. We say that is a principle that still applies today. And he goes on to say in 102 that this may cause difficulty with the tort of conversion because dishonesty is not an essential ingredient of this wrong. The defendant may be a thief, or he may have acted wholly innocently. Both are strictly liable, but it seems to me inappropriate they should be treated alike when determining their liability for consequential loss. In 103, he therefore concludes, this is all over, of course, I accept that, but he concludes in 103, this suggests that foreseeability as the more restrictive test is appropriate for those who act in good faith. Liability remains strict, but liability for consequential loss is confined to types of damage which can be expected to arise from the wrongful conduct. On the other hand, in 104, persons who knowingly convert another's goods stand differently. Such persons are acting dishonestly. I can see no good reason why the remoteness test of directly and naturally applied in cases of deceit should not apply in cases of conversion where the defendant acted dishonestly. So there is, in his view, a distinction to be made in talks of strict liability between defendants who knew what they were doing and defendants who were innocent.
Well, specifically those who are dishonest.
Yes.
And you're not suggesting that that applies in our case, are you?
No, there's no finding of dishonesty in this case. But there is an overriding principle, and it's not in the bundles, but there's the well-known case of Quinn and Leatham, the trades union case, which Clark and Lindsell quotes from in the remoteness section, and there they say that the House of Lords said the intention to injure disposes of any question of remoteness, and we say that that is a principle which still applies. In fact, in this case, the question of remoteness was admitted by the defendants, and so the intention, we say, was there all along, and we say that the judge didn't pay sufficient attention to that as a matter of policy, because for the reasons given by Mr. Justice Jacob, it's those sorts of cases where the defendant should be, if there's any deterrent effect of any of these types of recovery, those are the sorts of cases where it is most appropriate to apply it. So that is Kuwait. I don't know whether your lordships are in the habit of having a break for the transcript writer, or whether you would just like to keep going. I will keep going in that case.
All right, we'll rise for 5 minutes. Thank you.
What's yours?
Yes.
I was going to go on to Xena and Cantidec, which is one of the judgments relied on by the judge. I don't need to go in much detail, but just to outline the facts and point out why they were so different from the facts of the present case that the judge shouldn't have been tempted to try to draw parallels as she did. This is Bundle 2 of the authorities, tab 16. And picking up at page 556 of the bundle, paragraph 93. And so the background to this part of the judgment is the rolling platforms were the patented platforms, but the claimant was trying to claim for losses for fixed platforms as well as rolling platforms. And the argument that was put forward, in fact by my learned friend in that case, for the claimant was summarised at 93. So the overarching argument was that Mr. Smith, this is line 2 of 93, Mr. Smith said that Xena provided a one-stop shop, so new customers attracted by rolling platforms were also likely to hire other loading platforms. He gave an example, and then the next sentence, Xena also relied on the fact that it was an undeveloped market, that Cantidec promoted fixed and rolling platforms together, and that Cantidec's Cantidec's launch into this market was led by its rolling platform. That was accepted as a matter of fact, but it was found not to be enough. And if we turn over the page, pick it up in 95, Design Judge Burst says, although Mr. Cuddigan's claimant argument for these damages to be included is attractive, I do not accept it. The problem is with the detailed facts. This is not a case like Gerber, in which a non-infringing item, a CAD machine, interacts with the invention, a CAM machine, nor is it like Fabio Carini, in which damages were awarded for the loss of a chance of selling an entire tissue converting line, even though the invention was for one part of it. In this case, fixed platforms and rolling platforms are separate products used and ordered separately. And he goes on
just pausing there before we get on to the analysis. I mean, on your argument, that would seem to be irrelevant, that they're separate products used and ordered separately. Because you say, if there's factual causation and foreseeability and no policy to exclude, then subject to some other principle of legal causation, such as intervening acts of a third party, then you've got enough. Why should separateness of the products make any difference?
Because there has to be a connection between the infringing acts and the non-infringing sales which are sought to be recovered for.
Well, indeed, but then that's the acid test, isn't it? So what nature does there have to, of connection does there have to be?
A sufficient connection. That's an unhelpful answer. I can, of course,
Right,
accept
okay.
that.
But so we come back to the question I asked you before, which you declined to answer, which is you accept it has to be a sufficient cause, a sufficient connection, and that's then a value judgment.
Well, I'm sorry, I wasn't intending to decline to answer it, because in Lord Justice Staunton's example of the supermarket, you wouldn't be able to claim damages for the chocolate biscuits you buy if you go in to buy the patented nappy.
Because factual causation is not enough.
Well, yes, because factual causation is not enough, but there isn't a sufficient connection between the purchase of the patented item and
to be
the
sure,
chocolate biscuits.
but then the question is, how do we decide what is a sufficient connection and what is not a sufficient connection? That's what I'm driving at.
Yes, and as Lord Justice Staunton summarised in that case, it's probably a question of foreseeability or remoteness, and it's just too remote. There is an insufficient connection between the purchase of the chocolate biscuits and the purchase of the patented item to make it recoverable in that case. And that's exactly what happened in this case, in Xena. There was an insufficient connection between the sale of the non-patented items and the patented items. And you can see that on the facts in paragraph 96, because on the facts, the non-patented items were all sold first, and then the patented items were only sold in little d, the rolling platforms from June to September. And so, as the judge found, as he summarised in paragraph 97, Cantidec won the fixed platform hires lawfully in a way which had nothing to do with rolling platforms. The people hadn't come to buy rolling platforms and bought the fixed at the same time. They came to buy fixed, and they went away with their fixed platforms, unrelated to the sale of the infringing rolling platforms. And so, as
you say, this has really got nothing much to do with the present case.
Correct,
because we're not concerned with rolling and fixed platforms. It's all rolling platforms in this case.
Indeed, my lord. The judge correctly characterised the sales as non-infringing sales, but they were not non-infringing sales in parallel with the infringing sales, as they might have been in Gerber or in Xena. They were, in our submission, non-infringing sales in series with the infringing acts that are taking place in the UK. Because without the infringing acts in the UK, the non-infringing sales could never have been made. And that's not just a but-for point, that's a legal causation point. There are no circumstances in which Neo could have made the foreign sales if they had not infringed in the UK. And that's all based on other findings of the judge. And that's why we say there is a difference between this sort of Xena case, where Cantidec were perfectly entitled to sell fixed platforms, and they, on the findings of the judge, they were able to sell fixed platforms unrelated to the infringement, and that could have happened in any event, and on the facts that there wasn't a connection, and even Gerber, where, of course, Lectra were entitled to sell servicing contracts, but on the facts, as Mr. Justice Jacob found them, there was a sufficient connection between the sale of the servicing contract and the sale of the infringing machine to make that recoverable. But those are both cases where there's infringing goods and non-infringing goods sold in parallel, and the question is there sufficient connection between the sale of the non-infringing goods and the infringing goods? And that's to be contrasted with our case, where they are the same goods, and although technically they're non-infringing because they're sold abroad, without all the work that went on in the United Kingdom with the infringing goods to satisfy Johnson Matthey, to satisfy the car manufacturers, to go through all the prototyping, the sales abroad would never have taken place. And that's the contrast that we draw on the facts between Cantidec and our case, and why the judge was wrong to place reliance on Cantidec as she appeared to do. So the judge's summary in Cantidec is at 98 and 99, and in 98 there was an attempt to rely on the general entry to the market of rolling and fixed platforms together, but the judge found midway through 98 it cannot be said that in that case these hires of fixed platforms have been caused by Cantidec's infringement at all. Those fixed platform hires are not transactions which go together with Cantidec's hiring of rolling platforms, and he points out that the order of sales makes it clear, but that's not the only reason. And then he goes on in 99 to say, well, if I can believe that in a case in which a customer wanted a fixed and a rolling platform for the same job and arranged the hire contract at the same time, they might well have sought to hire both platforms from the same source. And that argument might get off the ground. And that's the similarity with the Gerber scenario in our submission, and the judge was right to make that observation. But neither of those cases are this case. And so we say the judge in this case, our case, was wrong to rely on Zena as she did. So that's Zena. Then in tab 20, if I can go briefly to Williams and Bermuda Hospitals Board, and I quite accept that I need to, or there's no point in spending time on the but-for question. But we say that Williams does go beyond but-for. And if I can pick it up, please, in Lord Coulson's judgment, begins on page 634, and then his analysis starts at 639. And in this analysis, he discusses Bonington castings in some detail. But the question in Bonington castings is set out by Lord Reid and summarised in paragraph 28 on 640. And what Lord Reid asked in that case was, he must make it appear at least that on a balance of probabilities, the breach of duty caused or materially contributed to his injury.
Yeah, but that's by way of an exception to the but-for test.
My lord, it may be, but it's also not the but-for test. So to the extent that I accept we shouldn't be looking at the but-for.
There's a lot of dispute about Bonington. I mean, some of the academics say that Bonington is in fact a decision on but-for, which other academics dispute, and one can understand why they dispute it. But I think the majority view is that it's an exception to but-for.
I accept that that is a way to characterise Bonington. What I'm trying to do is just get a couple of observations of Lord Coulson and Williams, which we say go beyond Bonington. So in paragraph 31, he seems to approve the summary by Professor Sarah Green, where she says, defendants should only be held liable for that part of the claimant's ultimate damage to which they can be causally linked. So
yeah, but you need to go over the page. She's talking about indivisible injuries. So this is this whole debate we get into post Bonington about divisible versus indivisible injuries and the circumstances in which the Bonneton exception applies. This is all about factual causation.
Well, I accept that, but the observations that Lord Coulson makes in this, he says that the injuries don't need to occur at the same time. And the question is there a material contribution by the injury? So if we pick it up in 39, he's saying the sequence of events may be highly relevant in considering, as a matter of fact, whether a later event has made a material contribution, or conversely, whether an earlier event has been so overtaken by later events as not to have made a material contribution to the outcome. But these are evidential considerations. As a matter of principle, successive events are capable of each making a material contribution to the subsequent outcome. In our submission, that's not just a question of fact. That seems to be a remoteness or a novus actus issue which he's addressing. Is that have the early events been so overtaken, even though they're but for, have they been so overtaken as to exclude recovery in those cases? And we say that the principle that Lord Coulson sets out there is not just applicable to the factual inquiry, it's also applicable to the legal test as well. And he goes on to observe, make observations on the single continuous process in Wiltshire 40 onwards, and justifies the decision in that case on that basis. And we, of course, we say in this case, it is effectively a single continuous process. The infringements in the UK were carried out with the intention of procuring the foreign sales, and therefore we draw parallels with Williams in that sense. Well, that's all I was going to say on Williams, and then the final two are just Manchester Building Society and Meadows, which are in the third authorities bundle. And so it's tab 30. And if I can pick it up on, first of all, on paragraph 4 of the judgment of Lord Hodge on sales, that's on page 946, and their summary of the issue as to where the scope of duty question should be located. Your Lordships would just remind yourselves of paragraph 4. That's where they acknowledge that the counterfactual may be a useful cross-check. And then they set out their 6 steps at paragraph 6 on 947, which again I'm sure your Lordships are familiar with. And so there's a question of scope of duty in step 2. Then step 4 is the factual causation question. Step 5 is the duty nexus question. And step 6 is the conventional tortious elements, remoteness, novus actus. That's the legal responsibility question. And we say that that's where the judge fell into error in this case, and the question of duty nexus doesn't really apply to a case about patent infringement. They go on in paragraph 11, they review Samco, and they observe in paragraph 12, in some cases a claim may be answered at stage 2 without the need to address the question of breach and factual causation. However, in cases where the scope of duty question is relevant to the extent of a loss of a particular kind, as in Samco and Hughes Holland, because those were both cases, information advice cases where you had to question the extent of the loss. It's generally more appropriate to examine this after first ascertaining on a simple but-for test basis what is the extent of the loss and which has flowed from the alleged breach of duty. And then they go on to explain at the end of the paragraph, in that sort of case, it's appropriate to ask the duty nexus question at stage 5, which it should be recognised, they say, that this is simply a practical approach to working out the implications of the scope of duty concept which arises in principle earlier in the analysis at stage 2. Then if I can go to paragraph 23, it's at E in paragraph 23, which is where the Samco cap comes back in, and they explain there, as Lord Sumption said in Hughes Holland, this is simply a tool for giving effect as to the distinction between loss flowing from the fact that as a result of the defendant's negligence the information was wrong, that's loss falling within the scope of the defendant's duty, and loss flowing from the decision to enter into the transaction at all by application of the simple but-for test. So they're acknowledging there that the Samco test is a way of narrowing the but-for result to allow only recovery where the loss actually flows from the negligence. And again, they acknowledge just below F that the counterfactual test may be regarded as a useful cross-check in most cases. And then finally, in 27, they identify the difference between themselves and Lord Legate, and Lord Legate's causation-based analysis and their own scope of duty analysis. We say that that difference doesn't matter in the present case. A couple of passages in Lord Legate to pick up, if I may, just in 973, where he gives some helpful advice in our submission, respectful submission, in relation to the counterfactual example. So it's paragraph 97, and he tries to correct perhaps some of the misunderstandings of Lord Hoffman's example. Perhaps I could ask your Lordship just to read paragraph 97.
Is that saying anything other than Lord Hoffman said? That in 2 or 3 times the sentences?
Possibly not. I suppose
that's my understanding of what Lord Hoffman, the point he was making.
Yes, I suppose what I rely on in the middle of the paragraph, just before D, he says, if the focus is on the consequences of the doctor's advice, the only way of limiting the extent of the doctor's responsibility for the injury is by invoking concepts of remoteness or legal causation. And so that is one way of approaching it, is to say, well, the injury that took place up the mountain was just too remote or not legally caused by the negligence. The other way of looking at it, he says, is you ask yourself what's within the scope of the doctor's duty, and he goes on to say, is there sufficient causal connection between the injury and the state of affairs which made the advice incorrect? And we say his reference there to sufficient causal connection is very similar to Mr. Justice Jacobs' reference to close connection in Gerber. And so that in our submission, they're all saying the same thing. There needs to be a sufficient link between the infringement and the damage to be recoverable. And that can be dealt with either as a matter of remoteness or legal causation, or it could be dealt with under the scope of the duty.
Insofar as there's any difference about this, the Legate is not in the majority.
I accept that, Lord, yes. Right. Finally, there's a passage in paragraph 117. Lord Legate made some observations about common sense, and and that we respectfully agree with him. Perhaps you'll read that.
Page?
117.
Thank you. No, page.
Oh, sorry, page 980.
Thank you.
I've always enjoyed Mr. Justice Langley's comments about common sense.
Well, we
I'm
all
about to say that having been doing this job for quite a long time, I have to say I respectfully agree.
Yes, all we say is it may not be the most helpful way of describing things because people's common sense differ. So perhaps need a more pointed analysis. Finally, Lord Burroughs, just in paragraph 203, it was clear that he agreed with the majority in relation to the role of the counterfactual test, and perhaps your lordships would just look at 203.
Page?
Sorry, page 1005.
Yes.
That's Manchester Building Society, and then finally Meadows and Calm. I'm not sure that we get much more from Meadows and Calm. I'll show you the passages which may be relevant. This is tab 31. So firstly on page 28, sorry, page 1019, paragraph 28, they set out in 6 steps. Page 1020, they start to address the scope of duty question in more detail. 1022, they, in paragraph 36, they go to address the SAMCO principle and when how that applies, and then they explain in 38 that they think it's more helpful to address scope of duty at step 2, but it may be necessary to address it at step 5 if there's a question of quantification, repeating the observations they've made in Manchester Builders Society. And then in paragraph 42 on page 1024, they address the breach question. Paragraph 44 on 1025, they address but for, the 4th question. And then paragraph 47 on 1026, they address the duty nexus question, the 5th question. And paragraph 49 is where they link that back to question 2. And they say the scope of duty question may also arise in relation to the extent of damage. And this is reference back to SAMCO. And then they go on to look at the facts of SAMCO and the difference between the valuer's negligence and the drop in the market in paragraph 50. And in 53, they say, well, the way of unravelling this is to ask the counterfactual question, what would the claimant's loss have been if the information which the defendant in fact gave had been correct? And at H, they say, the counterfactual assumes that the claimant would behave as he did in fact behave and asks whether, if the advice had been correct, the claimant's actions would have resulted in the same loss. And they go on to make observations on that. And they summarise the SAMCO question at the end of 54, just above C. They say, Lord Sumption cited Lord Hobhouse's statement that the principle highlighted in SAMCO is essentially a legal rule which is applied in a robust way without the need for fine-tuning or detailed investigation or caution. And then they go on to address the 6th question at 55, and these are the legal filters as described by Lord Sumption in Hughes Holland. That's at D, and those include remoteness, foreseeability, etc. So that's the way in which they've explained it in Meadows, and it's really, as we say, it's only the counterfactual question which may be helpful to identifying the cause, the legal cause of the damage, or questions of remoteness and foreseeability which arise in this case. So, my lords, with that, I was going to go to the judgment and explain where we say the judge went wrong. And again, your lordships will be familiar with it by now, but I was going to just work through the structure and show you the various elements the judge addressed. And if I can start off with her legal approach, which is begins at paragraph 82. So we're in tab 4 of the core bundle, page 42. And it's paragraph 82. And she sets out there the principles from Uracell, and she correctly sets out in little 2 the question previously set out by Mr. Justice Kitchens, who then was the last sentence of little 2, the tort must be, as a matter of common sense, a cause of the loss. A cause of the loss. And she emphasised little 3, damages are to be assessed liberally, and little 9, where damages are difficult to assess with precision, the court should make the best estimate it can, having regard to all the circumstances of the case and dealing with the matter broadly with common sense and fairness. Then she goes on in 84 to deal with Manchester Building Society, and she concluded that the guidance in Manchester Building Society and Meadows and Kahn do not substantially modify the established framework for a damages inquiry in the specific context of patent infringement, and we say she was right so to hold. Then she refers to some additional factors in 85. Again, she was correct to cite them. Little 1, damages are not a matter susceptible of precise estimation. Little 3, where the defendant's wrongdoing has created uncertainties, those should, where necessary, be resolved by making assumptions generous to the claimant, citing Gary Ferns. And then little 4, the court should also have regard to the extent to which it was in the power of one or other party to produce evidence on a particular point. Then she goes on to turn to the extraterritorial sales.
As for general principles.
And the principles, yes.
No, just the bit you've been looking at.
Yes, my lord.
10 out of 10?
Yes, in terms of what she
Yes.
set out as the law, yes. Yes, there's nothing wrong. Whether she applied it correctly.
No, I understand. I understand you've got an appeal coming, but yes. But so far as the, as it were, depth, breadth, and width of the self-direction,
Yes.
nothing wrong with
Nothing
that.
wrong
In
with
fact,
that, no.
absolutely spot on. All right, thank you.
Then she turns to scope of duty and foreign losses at 89 to 91, and she concludes.
So where have you gone to?
Sorry, I'm in scope of duty points beginning at 89.
Sorry, paragraph 8.
Yes, she says, I have some doubt as to whether the concept of the scope of duty and the tort of negligence has application to the infringement defined by the Patents Act. She notes in 90 that the Patents Act doesn't circumscribe the scope of damages. Section 61 just says a claim may be made for damages in respect of the infringement. And she concludes in 91, the question of damages for patent infringement should fall to be addressed on the basis of the general tortious principles of causation and remoteness. And we say she was right about that for the reasons I've already discussed with my Lord Justice Arnold. Then she goes on to review some of the law in relation to convoy goods, and she reaches her conclusion in paragraph 109 that recovery in respect of overseas sales should not be excluded a priori on the basis of the territorial scope of the protection conferred by the UK patent, and we say she was right to reach that conclusion. Then she deals with the enforcement.
I'm not asking this just to vex you, but so far again, as far as you're concerned, absolutely fine up to that point.
Then she deals with TRIPS and the enforcement directive in 110 to 117. And again, we say she was right to say that those didn't affect the conclusions she'd already reached about the scope of damages. Then she turns at 118 to the non-infringing alternative arguments. And these arguments took up a massive amount of time at trial, both on the law and on the facts, so much so that the judge made a costs order adverse to Neo in respect of these points, even though overall they were the winners. We don't need to trouble ourselves with it today other than this. She deals with the law, first of all, at 118 to 139, and then she deals with the facts at 140 to 155, and her conclusion, she summarises her conclusion at 140, where she says, Neo has not established that it could and would have been able to produce a non-infringing version of C100N that JM would have accepted in the development phase of its catalysts in the UK. And we say that's an important finding when we come to look at the counterfactual as to what is the situation in the presumed counterfactual to cross-check the judge's decision on causation.
But I don't understand this, and I'm sure it's my fault, but as I've understood it, you say the judge was correct to say that there's no issue of scope of duty in a patent infringement case because you just look at the statute, it's a monopoly, you've invaded the monopoly, it's all economic consequences, you say.
Yes.
If there's no issue on scope of duty, how do we get into counterfactual at all? Because the whole point of the counterfactual is a way of cross-checking, as we've seen from Manchester Building Society and Mayors and Khan, your conclusions on scope of duty and duty nexus.
Well, it's a way of testing whether something is a proximate cause or a common sense cause. I accept that the authorities do intermingle the question of scope of duty and the questions arising under step 6 of Meadows or Manchester Building Society. And that's why I showed you that passage where Lord Leggett said...
Yeah, but that's the point about him being in the minority. As far as the majority are concerned, they don't use the counterfactual at stage 6, do they?
No, but
and it's stage 6 that we're concerned with on your appeal.
Well, yes, to the extent that, but the counterfactual can still be used to test the remoteness question. And Lord Leggett observed that Lord Hoffman's Mountaineer example in remoteness, or it can be analysed under some sort of scope of duty question. Now it's not possible to apply a scope of duty question to patent infringement because there's no duty owed other than not to infringe. And so the question arises, well, have the infringements caused the damage? And that's the question that Mr. Justice Jacobs set out in Gerber. And one way of testing whether not only are they a but-for factual cause, but have they been the legal cause of the damage, is to ask the counterfactual question and say, well, let's just see what happened in the counterfactual and analyse whether or not the damage would have occurred. And if the damage...
Well, but again, let's take it in 2 stages. So far as remoteness is concerned, insofar as remoteness is the opposite side of the coin to foreseeability, why would the counterfactual help us on that?
Well, one way of analysing the avalanche in the Mountaineer's example, if it was an avalanche that caused the real injury.
And the avalanche was not foreseeable.
Well, that may not be foreseeable, or it may be too remote. You may say there's just an insufficient nexus between the doctor's advice about the knee and the avalanche on the mountain. Just as there's an insufficient nexus between the sale of the fixed platforms in Xena and the sale of the rolling platforms.
That way of putting it, I completely understand. And then we come back to the question I've asked you before, which is why is that not a value judgment for the first instance judge?
Well, in this case, she was wrong about that. She was ultimately, she got it wrong.
Yes, you prefer multifactorial assessment to value judgment, and you're presumably prepared to accept that a variety of judges could come to a reasonable variety of conclusions on a multifactorial assessment. And so what you're going to show us is why she was, as it were, not on the fairway.
Absolutely.
With her assessment.
Oh, yes.
Yes. Right, well, causation happens absolutely at the hinge of this judgment.
Yes.
And we've got to the halfway point.
Yes.
And you agree with everything that that she said so far.
Yes, indeed.
And not with anything very much that she says after this point. And the respondent, for the respondent, is rather the other way around.
Yes, I mean, in fact, we can go on, we can keep going. Obviously, finding on the facts, and her answer to the law is fine up until she comes to apply it. So let me identify where we start to depart. So
yes.
156, we say she was absolutely right. Not sufficient to show but for the infringement. Rather, it's also necessary to show that the infringement was, as a matter of common sense, a cause of the loss. So she gets it right there. She's looking for a cause, and she's citing Mr. Justice Kitchen. Then 157 she cites from Kuwait Airways, and she says in 158, the concept of common sense causation is essentially the same as the proximate cause requirement in the US jurisprudence, and she refers to Western GCO. Now, we prefer, and she just cited Lord Nichols in Kuwait, and as I took you to this passage earlier, we say when he was referring to proximate cause in the first paragraph that she cited, that's in contrast to something that's too remote. So he is analysing it as a question of remoteness, and if it goes too far, then it is too remote and not proximate enough. And we say that's the test he was applying. Then in 159 to 160, she makes the factual findings on but for, which plainly we agree with. But she goes on to say that in 160, the key question is, however, whether the infringing supplies were the common sense or proximate cause of the overseas sales. So far, so good. And in 161, she rejects...
I thought you might cavil at the...
Oh, the, sorry, yes, you're absolutely right. I do cavil at the in that sentence. Your Lordship's absolutely right, and then she comes back to that. So she has started to go wrong in that last sentence of 160. 161, she rejects the pleaded position from Neo, and this was... the pleaded position was that the cause of the damage was the manufacture in China, transportation to Macedonia, etc. And she says that's not right, and she rejects those reasons, and she says if that was the case, it would be the same in Gerber and Lecturer. And she summarises the question, the relevant question at the end of 161, if those losses are sufficiently directly linked to the sale of an infringing product. We say that's what Mr. Justice Jacob set out, and she was correct to characterise it in that way. She also correctly rejects Neo's arguments in 162 about the non-infringing. There were a couple of samples that were non-infringing, and she says that can't make a difference. In the middle of 162, she says it was part of a continuum of samples provided as part of an ongoing development and testing process that led ultimately to JM's approval of Neo C100N product for use in its catalysts.
Yes.
It would be wholly artificial to extract those specific samples and attribute dominant causal significance to those, the exclusion of the prior infringing sample of 888, which served as the reference point, or the subsequent supplies of infringing C100N, which were apparently used for customer fleet trials, which Mr. Williams described as being supplies that would open the door to bulk production of the product. So she was right insofar as she rejected Neo's attempt to rely on the non-infringing samples. And then she comes to the question of intention in 163. And perhaps your Lordships will just remind yourselves of what she said in 163.
Yes.
So she says their intention cannot create a sufficiently direct link between infringing and non-infringing sales. And of course, at one level, we accept that. You can intend something, but if it doesn't actually occur, then you haven't done anything wrong in the right sort of tortious situation. But we say here, where the intention was present, and then, in fact, what was intended occurred, we say that that is and should be a sufficient link between the defendant's infringing acts and the damage that is claimed to justify damages being awarded. And there are two additional points I'd like to add to 163. Firstly, I want to show you the admission that was made, just so you can see quite how close it runs to the damages that were claimed. So it's best summarised in Mr. Justice Mellor's judgment in the supplementary bundle at tab 6. So it's tab 6, supplementary tab 6, page 40. And at the bottom of page 40, this was a judgment given after a hearing about disclosure in the inquiry. And the question was what disclosure needs to be given on causation by Neo. Neo's submission was that they didn't need to give any disclosure because they were giving certain admissions, and the admission was summarised in 27 and on top of page 41. And the reason I'm going to this because the admission was given over a number of different documents, and this is the summary of it. So Neo accept that their intention and objective in importing and keeping in the UK and supplying development samples in the UK, and as applicable C100N commercial products to JMI, was to procure a commercial contract with JMI for the sale of C100N, whether supplied inside or outside the UK. So it was admitted that the infringing acts were designed to procure commercial relations outside the UK. And we say that, that there was a very important admission on intention, and it was also the actuality, because that's in fact what happened. And although the judge was right to observe that in some cases intention might not be enough, where the intention has in fact resulted in damage, we say that that is a complete answer to remoteness and also an answer to any policy arguments which might arise in these sorts of cases. We say there is clearly a sufficiently direct link between the infringing acts and the damage for it to be recoverable. My Lord Justice Arnold may be most familiar with how this arises in passing off cases. In Office Windows, Lord Simons memorably commented, if intention to deceive is found, it will be readily inferred that deception will result. Who knows better than the trader than the mysteries of his trade? And we say, in this case, where intention to procure these foreign sales was admitted and in fact occurred, we say that damages should follow as a matter of policy and as a matter of remoteness and or foreseeability. And that we say is an important point which the judge didn't place sufficient weight on. 164.
If you're leaving 163,
Yes.
She says she says it doesn't seem to her can create a sufficiently direct link. She goes on to say it may well be relevant to the assessment of whether such a link exists. Do we find it again in her analysis?
I don't think we do. So that's one of the reasons we say she didn't put sufficient weight on it. Then in 164, we see the repetition of the error first posed in 160, reference to the common sense or proximate cause. Which is a more direct link is, in my judgment, required in infringing supplies to be regarded as the common sense or proximate cause of the overseas sales. And we say she has gone beyond the correct legal analysis here by looking for the cause, and she's diverging from the normal tortious principles of remoteness and foreseeability that she had earlier said were correctly to be applied in this case. Then in 165, she seems to pivot to a sort of Gerber and Zena analysis. And she says, in that regard, it seems to me that the crucial question is the importance of the infringing supply in influencing the customer's decision to purchase the non-infringing product. And she goes through a spectrum of possibilities. She says, there may be an inextricably related sale, and that's the sort of thing in Gerber. Or she says there may be a less direct link in 166, where the customer requires both products for a single purpose and therefore seeks to purchase both products from the same source. And then she gives an example of Xena systems, where she says that wouldn't be enough, reflecting his Honour Judge Burse, this is 168. The mere fact, therefore, that the supply of an infringing product allows the infringer to enter the market does not in itself create a sufficiently direct and causal link between the infringing and non-infringing sales. Put another way, the fact that an infringement creates an opportunity to sell a non-infringing product does not mean that the infringement causes the non-infringing sale. And so our submissions on these passages are as follows. She has sought to try to impose a Gerber or Xena systems analysis on the facts of the case before her.
But she hasn't got to the facts of the case before her. This is all at the level of generality.
I accept that one, but what she goes on to do, she relies on these passages in order to eventually say, well, I think this falls on the Xena side of the line.
Okay, but we'll get on to her application of the principles to the facts of the instant case in due course.
Yes.
But at the level of principle, where do you say she's gone wrong? Because I understood you to accept earlier the supermarket example.
Yes.
And you likewise didn't say that Mr. Justice Burse was wrong in Xena.
No.
I appreciate that you say that his reasoning is misapplied by the judge on the facts of this case. But where, therefore, is she gone wrong at the level of principle in this discussion?
I can't criticise these paragraphs for what they summarise, the way they summarise the law.
So she's right on the law in these paragraphs.
She's right on the law in these paragraphs. Where we say she errs is to say, having concluded that an opportunity to sell is not enough, to say that this is an opportunity case. So I would quite accept...
That's a different one.
Yes, it is.
Right.
But I would accept that one way of characterising Lord Justice Staunton's supermarket example is to say, well, you go into the supermarket for the patented goods, you've got an opportunity to buy chocolate biscuits while you're there, that is not a sufficient causal link. So to that extent, I don't say there's anything wrong with these paragraphs. What is wrong is when she then goes on to say that this is an opportunity case.
But I mean, taking the page that you've been addressing, sort of 59 onwards, how do you square what she's doing there with the heavy emphasis that you've been placing on A and the? At the bottom of page 58, she's referring to the common sense or proximate cause.
Yes.
Is it not apparent on page 59 that she's not putting herself in a straitjacket and saying, I must look for the proximate cause?
I accept that.
She's actually looking at where things lie on a spectrum ranging from the cause to, at the other end, a mere opportunity.
Yes.
So, I mean, we're obviously going in the end to read the judgment as a whole, but at this stage, it seems to me at least that if the judge misspoke, then she wasn't, at least at this stage in the judgment, deceived.
I would accept that. The heart of her error is really in 169. We would say on her legal analysis, and it's clear that she is, when she says in the beginning of 169, in similar vein. So she's clearly seeking to try to apply the scenarios she's discussed in Gerber and Zena to the present case. But she goes wrong here, because she says, if an infringing supply brings a product to the attention of a customer who subsequently decides to purchase a non-infringing version of that product instead of a competing patented product on the grounds that the former is cheaper and more widely available, then it seems to me that an intuitive analysis would regard the cause of the sale as being the customer's decision based on price and availability, those factors being decisive in influencing the choice between the two products. The infringing supply would, in that example, have undoubtedly created the opportunity for the non-infringing sale, but would not be regarded as the common sense cause of that sale. Now, the problem with her analysis in 169 is that on the facts of this case, this isn't a case where...
Well, hold on, but again, you're going off onto the facts of the present case.
Of course.
So you say the heart of the error is in 169. So tell us where the flaw in the legal analysis is in 169.
Yes, there is nothing, in the first sentence, for instance, there's nothing wrong legally with the observation that if an infringing supply has merely brought a product to the attention of a customer, and they go on to decide...
Right, so there's no flaw in the legal analysis.
No, but it's the fact that she is making these observations when the situation that she then goes on to describe is not this. It's not.
Well, but then that's a different point. Yeah. The point is not that she went wrong in 169, but that she went wrong later when she came to the facts of the present case.
Well, that may be.
Whereas I had understood you to be saying that she went wrong in her legal analysis in 169.
Well, she goes wrong insofar as she is looking for the cause. She refers to the cause of the sale being the customer's decision based on price and availability, right, and the common sense cause in the bottom of 169.
Right, so what we've got so far, and we're now on page 33 of the 58-page judgment, is that you have no complaint about what's hitherto appeared, with the exception of the the issue. But actually, your concern is not really so much about the A and the, because we can see her doing an A analysis rather than a the analysis here. Your complaint is that she's not doing the distinction between series and parallel, which you drew to our attention earlier on. Well, and that's, yes. So in a sense, you're saying that she was entitled to view these cases as she passed through the law, but she should have, when she came to apply them, have directed herself that they're not actually about the case in hand.
Well, yes, that's correct. And so in 170, again, she asked the question, were the infringing samples a sufficiently significant driver of the overseas sales that they should be regarded as the common sense or proximate cause of those sales?
Well, you might have equally emphasised, as we're adding emphases, that whether they were a sufficiently significant driver of the overseas sales that they should be regarded as the common sense. I mean, it seems to me that the textual analysis is it's there to be made, that one can't put undue weight on it.
She then turns to the evidence, and she notes in 171 the problem that there is no evidence from Johnson Matthey. And we say that this is the reason that there was no evidence from Johnson Matthey is Neo's infringements, and that Neo's infringements have placed Johnson Matthey in a position whereby they didn't want to give evidence in relation to a dispute between two of their most important suppliers. And so to the extent that there is an absence of evidence, we say she should have applied the principle, this is really our third ground of appeal, she should have applied the Gary Ferns principle.
So I don't understand that. Well, obviously, we'll get onto the detail in due course. But first of all, it's absolutely common for customers to want to stay neutral in disputes between two of their suppliers. That's absolutely commonplace. What's that got to do with whether it's infringement or not infringement?
Well, the reason that JM might have given evidence in this case is because Neo had carried out infringements.
All right, but then we've got to go into further questions. First of all, we know, because she says in little paragraph 1, that evidence was given by two people who were there in JM at the time.
Yes.
So it's not as if there was no evidence from what one might call JM sources.
That's right, my lord, but they were not.
So then the question is, what was missing? Because insofar as what was missing was a witness presently employed by JM, did you issue a witness summons to any such witness?
No, my lord, we didn't.
So that's a step you could have taken to obtain witness evidence from a JM witness, but you didn't take.
My lord, that's because JM...
And why is Neo at fault for that?
Well, Neo put us in the position by carrying out the infringements that JM didn't wish to assist either party.
But you accept, you chose not to issue a witness summons to a JM witness.
My lord, yes. But just as your lordship points out that customers don't wish to get involved in disputes between their suppliers, one can also understand why it might not be desirable for people from customers to be forced to come to court to give evidence. And so, looking at this commercially, JM decided not to become involved, and the reason that they could have been involved at all were the infringements, and that is something which we say should be held against Neo. The other point to make on this is that Neo's witnesses gave evidence that JM were covered by an indemnity from Neo, and so presumably if anyone was able to persuade JM witnesses to appear, it would have been Neo, as they were providing the indemnity, and that's a further reason why we say that any inferences to be drawn from their absence should be inferences made against Neo. Certainly not something that should be held against Rhodia. The other point to make...
Where did the judge hold the absence of a JM witness against your clients?
My lord, she didn't, but the point I was going to make about Dr. O'Sullivan and Osborne, who did give evidence, neither of them were directly involved in dealing with Neo during the infringing period. So, although they did assist the court in their evidence, to the extent that we didn't have direct evidence from JM about what they were thinking when, about Neo's supplies, that was a...
So the best source of that information would have been disclosure from JM. Did you apply for third-party disclosure against JM?
We didn't.
So again, that was your choice.
Well, the best source of that information may have been Neo's managing director, Karen Brown, who was the person who ran the account.
And you reduced her evidence.
She was only employed by Neo until September 2021. As the judge recorded in paragraph 25 of the judgment, she had left Neo by the time of the trial and provided neither written nor oral evidence at trial, except by way of affidavit.
So you put the affidavit in, and you didn't issue a witness summons against her?
We did not.
Right.
But leaving these matters as... Leaving these matters aside, how does this get into the appeal? Because this isn't an appeal against the judge's findings of fact. it's an appeal from the judge's evaluation.
Yes.
So what does it, in the end?
In the end, it
Matter.
probably only goes to the question of dual qualification, where there was conflicting evidence from witnesses on whether or
Right.
not.
And remind me, is that a ground of appeal?
That is, it's the third.
Which one?
Third of our grounds of appeal.
Right. So that's the.
The Amory principle.
Yes. Okay. So all this goes to. It's actually the fourth ground of appeal. Is it?
It may be. Yes.
Amory dual qualification.
Yes.
Okay.
But my primary submission is it doesn't matter. It shouldn't matter, and so I'm content to deal primarily
Right.
with the judge's.
Okay. Well,
findings.
we've got to that part of the judgment.
Yes.
Where do we go to next?
Then we go to 172 and 173, which is effectively where she summarises the evidence I showed you earlier
Yes.
about the way in which this process takes place. 174 is where she introduces the dual qualification issue, and she refers to Ms. Brown's evidence where Ms. Brown said you wouldn't want to dual qualify more than one supplier because of the cost. And as I say, we say on our primary case this makes no difference. But the main issue, of course, here is whether they were dual qualified or not. The crucial point is that Neo were only in a position to offer cerium oxide for the catalyst to Johnson Matthey as a result of the infringements. And it didn't actually matter whether they were competing directly with Rhodia or not. The judge found, as a matter of fact, that they were competing, and this is really her summary in 180.
Well, just since while we're on this point, because I know it only comes in later on your appeal, but since we're looking at this page, it's helpful to pick it up now. At 177, she records that you put it to Mr. Knoll. The note indicated that Neo and Rhodia were dual qualified on each of the 4 platforms referred to, and Mr. Knoll agreed that that was his interpretation. Now, firstly, is that a factually accurate record of what happened at trial?
It is, yes.
Now, if you put it to the witness and the witness agreed, why are you not stuck with the answer?
Well, because there was evidence from Mr. Knoll, and there was also evidence from Ms. Brown, as I've referred to, and she was closer to the issue than Mr. Knoll. Mr. Knoll was recording, being
So
asked
you
questions.
didn't put it to the witness, you don't know. You put it to the witness. This document shows that they were dual qualified. He agreed. Why are you not stuck with the answer?
Well, that was his interpretation. He said that's my interpretation of the email. So I don't shy away from that, my Lord.
I think the short point is we can't criticise the judge, can we, for recording a bit of recording accurately, a cross-examination and an answer.
No, I don't criticise that. But by the time we got to closing,
And then relied on that to conclude that they were dual qualified.
yes, by the time we got to
But
closing,
all of this doesn't matter. Your point is they were only dual qualified because they'd cheated.
absolutely, Mark.
That's the point.
Yes, it is. And that's why we say it makes no difference.
Yes. Well, can we move to bits 2?
Of course. So 182. So she deals with dual qualification in 181. 182, she comments on the commercial substitutability of the products.
Yes.
And she seems to use that as a reason against Rhodia when it comes to her discussion and analysis, and the fact that Neo could provide an alternative product that was slightly cheaper. She says, well, in fact, it was the cheapness that was important for the damage. But of course, as we say, it's a point in our favour that there was substitutability, because the only reason that Neo could offer a product at all was because they were infringing, and that's the only way that they could sell any of the make any of the overseas sales that they did. Finally, in 183 and 184, she refers to the absence of supply contract for Neo and indeed for Rhodia until the date mentioned in paragraph 184. And again, she seems to think this is something in favour of not finding causation, and we say that again was an irrelevant consideration. Supplies were expected to take place. The fact that they weren't preordained by a supply contract can't make any difference to the fact that the damage did occur and was caused by the infringements that had earlier taken place. So finally we come to the last really 10 paragraphs of analysis where she draws together her reasons.
Well, shall we take a slightly early break?
Yes.
And start those at 5 to 2? Thank you. Thank you.